I'm Jay Schwartz, Chair of the Building Board of Appeals. I'd like to open this meeting. We will start with an introductory statement. I'm sorry. Let's introduce ourselves.
Good morning. My name is Ryan Webb.
Good morning. I'm Bob Ruby.
Counsel Jay Schwartz, Kimberly Consoli, Administrative Assistant. So much. The Building Board of Appeals is established by City Code 02.48.050. The Building Board of Appeals task today is to determine whether or not the City of Annapolis, under Title 17 of the City Code, followed the applicable code requirements and used reasonable care and consideration when approving or denying a permit in question. Additionally, the board will determine whether there is substantial evidence to support the city's approval or disapproval of the permit in question. If the board determines that this appeal is outside or beyond the board's jurisdiction, as defined by the city code, the board may dismiss the appeal prior to receiving any testimony or documents relating to the merits of the appeal. Additionally, if the board is convinced that testimony offered by any party is clearly not relevant or material to the issues on appeal, the board may rule either that the testimony not be received or that the testimony be limited. Finally, a person aggrieved by a decision of the Building Board of Appeals made pursuant to this section may appeal that decision to the Circuit Court for Anne Arundel County pursuant to Maryland Rule Title 7, Chapter 200, as may be amended from time to time. I'd like to swear in the witnesses. If you intend to testify, please stand or raise your right hand and affirm. Do you swear or affirm under the penalty of perjury that the testimony that you're about to give to the Building Board of Appeals is the truth, the whole truth, and nothing but the truth? Thank you. I believe we have some administrative matters. Any questions, gentlemen? On our caseload today, our only today is we heard of an appeal on 8/29/24 on a fence permit. The circuit, and we denied the appeal. The circuit court remanded it back to us and said we, in effect, misunderstood a word in the code. The term shall be construed as must, unless other specifically noted. That's the language of, so it was ordered back to us to review. This original appeal, permit appeal, was the city of Lisa Mantha and James Palumbo versus the City of Annapolis, case number fence 2024-0042, 31 Georgetown Road. It was a fence permit. It seems to me that we have heard this before. And what is before us now is whether we properly interpreted the code. And the code in question is what type of survey is required. And the appellants argued that a proper survey was not produced. The City of Annapolis said it's what they normally see. We use that, I believe, in our discussion. But like today, I think we need probably a motion to limit this discussion today only on whether the survey was appropriate or not. But I need the board to weigh in on that and discuss that. Thank you.
I would agree. I think limiting the discussion is certainly reasonable in this case.
I agree. That's the
Speak up, please.
that is one point that I think clearly demonstrates that city standards.
Lean up, make sure that's on. Okay. Well, that's for us to decide today, I think. I think I need a motion if we want to limit this to only that issue.
Uh,
We don't need a motion.
we looking for a motion?
No motions required. Thank you. Today's hearing, we will limit discussion on whether the appropriate survey was produced and submitted. If it was not submitted properly, then I suggest a permit should not have been granted, and it should not have come to us. Will the appellant please present the first case?
Sure. George Mahaffey on behalf of the appellants, the petitioners, Mr. Palumbo, Ms. Mantha. Mr. Schwartz, you correctly said why we're here today. We're here because of a remand from Judge Malone, an order issued June the 30th of 2025. He found that the decision was an error, the decision that was rendered here. There was a hearing here on August the 29th of 2024, and then there was a written decision that was rendered on December the 6th of 2024. Really, the key issue there were the minimum requirements for the permit at issue, which was fence permit number 2024-00042. Were those met in terms of code compliance? Were the minimum requirements met? Now, interestingly, I read the transcript from the August 29th, 2024 hearing. Some people got it correct. I don't know if the speaker was identified, but one of the speakers said at page 57, the minimum requirements for the permit for this fence were never met. That was correct. They were right. And the reason is because there were certain requirements that stated shall be done. Shall is mandatory. It's not discretionary. The mistake was in the decision that came out on December the 6th, and even in the hearing on August the 29th, there was some confusion as to whether shall is discretionary, mandatory. It's mandatory. It always is under the law. So there was a mistake that was made. The issue was that the minimum requirements for the permit here were never met. You've seen our written submission. You've seen what the issues are. There are a number of issues. Number one, the fence is not constructed properly.
Forgive me.
Yeah.
We're going to keep it to purely the first issue, which was the survey.
We can keep it. You asked me to give a recitation of the facts. And so the bottom line, I'm just telling you from a macro level, the bottom line is the mistake was made when the decision was rendered here on December the 6th of 2024. It was an error. We went up to Judge Malone. Judge Malone agreed. He sent it back down. So the bottom line is that the minimum requirements for this permit were never met. I mean, I can walk you through all of the various issues. We can talk about the one issue about the survey. But the bottom line is this permit should never have been issued. The appeal that was lodged by my clients should never have been denied. It was denied in error. That's why it went up to Judge Malone, and that's why it was sent back down. So this permit should never have been issued to begin with. It's an error. It's not code compliant. The minimum requirements were never met. That's the bottom line.
Thank you.
Yes.
And what, if you can, give me a short summary of why the survey was in error or not complete? Can you do that? It's purely the language of the code.
Sure. The language in the code says that the permit plan should be provided, shall be accompanied by a scale drawing showing the proposed location and dimensions of the fence on the subject lot and its relationship to the property lines, existing structures, existing trees, and steep topography. Now, when I listened to the hearing on August the 29th of 2024, again, there was confusion as to what was required, and I think that there was some back and forth. And by the way, the transcript is a little unclear as to who was speaking. Some folks weren't identified. I don't know, sometimes that happens. And then some people are like, well, we don't always get the information. Sometimes we just accept things the way that they're handed to us. But the code's the code, right? The law is the law. When I went up to Judge Malone threw up his hands essentially and said, the code's the code. You guys got to follow the law. Shall means shall. So these things weren't done. I mean, that's just one thing. There were many other things that weren't done here. So the permit should never have been issued. Bottom line, it's in violation of the law. So,
Thank you.
Yeah.
Will the city want to respond to this? Give us your that. Introduce yourselves, please.
We don't have anything to
Right, nothing yet. Yeah. So I have a question for Mr. Manassa or Mr. Meekins or the city. In our previous discussion, it's for the record, what is typical that the city requires for a survey? And has it now changed?
So first of all, Mike Meekin, Senior Planner in Planning and Zoning. To answer your first question, what do we typically accept? We have, at the time that I testified a year ago, approximately, I had reviewed for that year approximately 90 some permits. And we get a variety of applications and supporting materials for those fence permits. So we, in general, accept applications such as these. Some are more watered down and some are more specific. So there's a range, admittedly, that or a threshold of information that we are looking for, namely not only the dimensions and material of the fence construction, but at a minimum, a site plan that depicts the property outline and where the fence is proposed. That site plan, in some cases, could be hand-drawn by the applicant. In some cases, they could be a legitimate survey, a survey plat of record. So it's kind of all over the board.
So under the strict definition of the code requirement, did this permit application meet the guidelines?
No, it lacked topography and or steep topography and location of existing trees.
All right, thanks so much. Gentlemen, questions?
No questions at this time.
I'm going to close the public. We're going to put, excuse me. We're going to close the public portion of this discussion, gentlemen.
Based on the city's testimony, I would move that we, or I think, I don't know that I'm ready to move anything, but sure, sorry. I think that it is, the permit should not have been issued. I would agree with the city and the appellant in this case.
I'm in agreement with that due to the fact that the survey doesn't meet the city's standards as written in the code, that this permit should not have been issued.
Even though the application was typical of the last 10, 20 years, permit applications.
So I would say the city has in the past perhaps erred on the side of working with the public who have, obviously lots of fence applications that they're putting up all the time on their own individual property that does not affect, 6, 7, 8, 10 homes as this one does. And so perhaps, or I would say, good on the city for doing that and working with the public. But in this case, that fence affected so many homes that it should have been held to a higher standard, to the standard of the law.
Yeah, and the code doesn't distinguish to what level you have to follow it in these situations. And I understand that, a small single-family homeowner that goes to put up a fence, being required to produce a survey, could be financially really difficult. It could cost more than the cost of the fence. This case is different. The code doesn't distinguish this, but this case is different than your typical single family.
We make a motion.
So let's see if I'm saying this correctly. I motion that we find in favor of the appeal on the basis that the application was incomplete due to the fact that the survey doesn't meet the city's standards as written in the code.
You want to reference the code section?
Referencing code section 1734.0 section A, 2A.
Okay.
Second?
Call for a vote.
I call for a vote on the motion.
It's my
Oh,
turn.
you do that. Sorry.
In favor of this motion. And voice, please.
Aye. I vote in favor.
Aye, in favor.
Thank you. In favor, I usually don't. Aye. I usually don't vote unless there's a tie. Yes. Got it. Thank you. Any other discussion?
No, thank you.
Thank you.
Thank you, guys. Appreciate it.
Administratively, let's minutes from the past meetings. It doesn't matter. I wasn't here. We can't prove it. Gentlemen, they'll probably appeal again because we threw out all the other ones. We didn't throw them out. We didn't hear it. Well, the original appeal.
Are we off the record?
Yeah. Hey, John.